Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. And today I am with my guest, Nate the lawyer, my fellow lawyer from New York, here to keep me and everyone else in check and make sure that we are observing reality. How are you doing today, Nate, in the real world?
It has been a wonderful day. I've lost some money at a casino. I've
Good.
just gotten back home, relaxing, got back in the whole school with the kids, housework, and all this other stuff. And I'm arguing with clients, but it's just another week for me. So how's everything going with you?
About the same, except less with the gambling losses. Some weight losses though, and so that's nice. But
Oh man,
we're making progress.
I need to get down like 10 pounds or something like that. It's funny
I need
because
to get down like 100 pounds.
For the COVID vaccine, I'm too healthy to get the vaccine, but I'm fat enough where I got to worry about getting sick.
Nice.
So I'm in that weird space.
Coming for us all in the end, man.
Oh my God.
So I thought we could start with my friends in the Ninth Circuit just came down with a decision en banc relating firearms rights, an open carry from Hawaii. You remember this case?
You're gonna be hit me with everything new because I've never heard of this case. What's going on?
So some people wanted to open carry in Hawaii, and they sued in district court, and the Ninth Circuit Court of Appeals, in the 2-1 decision, said, "Yeah, you have the right to carry open carry," which was a surprising decision. You wouldn't normally expect that. So today they came down with their en banc decision and then said 7-4. Actually, not so much. You do not have the right to open carry unless you get a permit. So you don't have a right to open carry just on its own. Now, if we combine that with California's decision from a couple of years ago that you can't conceal carry without a permit, then we now have both halves of this decision, right? Presumably. We have a decision that says you can't conceal carry without a permit, you can't open carry without a permit, and permits are hard to get in California, although they're issued on the county level, so it depends what county you're in. And it's borderline impossible to get in Hawaii. So if we were looking for like the complete legal package at this point, one would presume we're there. Because, the both halves of the question have been answered by the same circuit. You don't have the right to conceal carry without a permit. You have the right to open carry without a permit. Presumably those are all the options. So you can't carry without a permit. And so the question would be, and they don't issue permits, as a practical matter. So it seems like it would be right for the Supreme Court review. So I guess the question is, as always, will this be the year the Supreme Court decides to grant a backbone and actually hear one of these gun cases, or will it be a continuation of the last 10 years where no, not so much?
Well, it'll, as an academic, I don't see the problem with these rulings. And the reason is because it's consistent with the core right in McDonald and Heller, if you want to be frank. And the core right that Scalia created out of whole cloth was the right of one to have a firearm for the protection of one's home. Right? That was the McDonald rule. That was from Heller.
Sure.
And that core right, and obviously there were some limitations on the right. If you guys go and read some limitations, they even spell some out. Felons, for instance, can't have guns, and you can have reasonable regulations. The assault weapons ban for certain types of weapons, and outside. But the core constitutional right that was placed down by the king of conservatism was the right to have a firearm and the home for protection. Now, I don't think that extends to if you're outside the carry.
It doesn't on its own terms. It doesn't on its own terms extend. That's true.
But now, if we're talking about judicial philosophies here, from my perspective, you've always been an originalist, textualist conservative, right?
That's what I'm going for.
If it's not in there,
right,
you don't just make up the right. But now we're at the point now where Scalia's made the right to own a firearm in the home is one that is made up of whole cloth. It's an interpretation of the Second Amendment. You can say it's there or it is not. It's the same thing as the right to bodily autonomy. It's there, but it's not. 10th Amendment. But now, if you're asking for an expansion of McDonald as an academic, that's what you're asking for. You're asking for an activist court to expand McDonald to have the constitutional right extend outside the home. Is that the position? But now, are you saying that right is a core right? How are you? My question is that expansion? how do you as a textualist and originalist,
right,
how do you justify that expansion of the right?
fair enough. So we can start with what Scalia did write in McDonald, and he can say where he says that the right is both fundamental and individual. So it belongs to each person individually, which was a question before DC versus Heller about the militia clause and how it impacts. But it's an individual right, and it's a fundamental right. So that's the first place to start. Then obviously the linchpin language that I'm looking for in the constitutional text is keep and bear. What does that mean? Now, that could be like one thing, keep and bear. So that could be one phrase, or it could be two different things, to keep and to bear, as two separate phrases. So either way, the Supreme Court in Heller and McDonald was only answering the keep question. What does it mean to keep? And if you think about like, okay, so it's an individualized, personalized, fundamental right. I have a right to keep, at least in Fourth Amendment law, right? The home is treated as special. I mean, we know this very well. The Fourth Amendment is the man's castle, the last refuge, the place of the highest rights. And that even extends to First Amendment rights. Correct me if I'm wrong, but didn't the Supreme Court rule that you even have the right to possess obscenity in your own bedroom?
Yes. And let's not forget you had Lawrence v. Texas too. Lawrence v. Texas.
So even though obscenity can be banned by the
council.
State, right? Yeah. So even though obscenity, truly obscene material, can be banned by the state, even that doesn't extend inside the bedroom because the home is special. So you say, okay, the rights are at their paramount inside the home. So what would it mean for an individual to be, because it's individualized, to be able to keep a firearm? Well, presumably that means some version of having it available and access because I'm keeping it, I'm holding on to it. And so if my rights are paramount inside the home, and those are the greatest measure of my rights, First Amendment law, Fourth Amendment law, why not Second Amendment law, right? So that's how I see it, where you get that. And then, of course, that's the place of core right, but it doesn't necessarily on its own terms imply there isn't a right somewhere else. It just says the right must be here because this is the most extreme example. If it's not here, it's not anywhere. So the court says, okay, it's here inside the home. And then, okay, so then the next logical question, right? So it's like, okay, can I take it outside the home? And you could ask that two different ways, right? So if you were thinking, can I take it outside the home for the purposes of going to target practice, right? Rather than having it on me, right? That might be still part of the keep because I'm not bearing arms. I have it locked in my trunk. I'm taking it to the shooting range. And it's part of my ability to maintain my proficiency and part of my ability to, to exercise, make sure that I'm familiar with firearms so that I'm able to use the firearm if I need to. So maybe for those kinds of purposes, that's still to keep. But it's like, okay, what does it mean to bear firearms? And at least to me, it doesn't make sense really to talk about bearing firearms in one's home, because McDonald was about, Heller was about this security guard who lived in his home, who wanted to have the firearm for sufficiently ready use that he could use it if he needed to use it inside the home. And that was within the keep matrix, not the bear matrix. So even if you are using the firearm in that context, it seems to be within the keep matrix rather than bear. So I don't think it really talks. Yeah, go ahead.
Well, one thing though, from my understanding, Heller, which Scalia wrote, and Alito wrote McDonald, but for Heller particularly, it was the installment of the Second Amendment is an individual right, because before that, the Second Amendment hadn't been interpreted as to grant the individual right. It was always a machination of the state. The state can regulate it, but this was to say you as an individual have the right to bear arms. Am I wrong with that?
Yeah, I mean that's Heller, that you have an individual right to bear arms. Yeah. Well, you have an individualized right to the Second Amendment, whatever its compass is.
Okay.
So whatever the Second Amendment is, it's an individualized, fundamentalized right. So yeah, that much for sure.
So I understand your argument. In other words, you're saying that because Heller was, you have a right in this particular space, this special space, to bear arms, just like you have a right to obscenity. But yeah, I don't know.
So at least that much. And in the same way in the Fourth Amendment law, just because the Fourth Amendment law is at its peak inside the home doesn't imply you don't have the Fourth Amendment right outside the home.
But then what? But then why? Why keep those same limitations? Felons, for instance, a felon still has the right to obscenity in the home, but they don't have a right to own a gun in the home, right? A felon has the right to tell people to leave his home, right? They have a right. So this would be a right now that in that core concept of the home, there are many. Matter of fact, I would argue that this would be the only right that the felon wouldn't have. So doesn't that itself make it unique? Because now you're saying that certain people have, felons, for instance, can have this right and certain people cannot have this right. If the house is the thing that makes the difference, if being in the dwelling makes the difference, then it should make the difference for the felon also.
Well, the whether or not a felon should be able to possess is a wholly separate issue, right? So that could be attacked on its own merits, given the grounds that you just said, especially for nonviolent felons. Nonviolent felons. There was a great law review article that I read one time. It says, why shouldn't Martha Stewart be allowed to have a gun? Because Martha Stewart was convicted of a felony, although it's a white collar crime felony. So not to say she didn't do a bad thing, but like, why should she be barred? So there is an argument there for felons. But whatever the argument would be for felons, let's take the easier case. The easier case would be your law-abiding citizen who can pass a basic background check, and so forth and so on. So because if he doesn't have the right, we don't even have to ask about the felon case.
No, but just to be clear, my use of the felon case to a line is because you seem to attach the Second Amendment, the rights pronounced in Heller, to the castle, to the dwelling, and saying that in the dwelling you have these rights, right? These are special rights. And you brought up even an example of obscenity. So I'm saying, but I'm saying if we're going to analogize it to that, then we have a whole bunch of rights there too, and all these other rights. But now those rights are somehow separate from the Second Amendment, right? Because of the felon issue, right? If you're a felon, this is one of the few rights. Those rights, I think, when you're talking about the rights of like ejecting people from your home and all these other rights, the obscenity rights, it is based on the dwelling. But I don't think the Second Amendment has that. I think it's more attached to the person and not the fact that you're in a dwelling. I think the dwelling is where the right's at the maximum, but I think that right is actually attached to the person, where the obscenity law is actually attached to the dwelling. I think that's a fundamental difference between the two rights. That's why, in one instance, the felon loses his right to the Second Amendment because of the individual right taken away. Where if he was in his home and he did this in obscenities, then he wouldn't lose that right because the right is attached to the castle.
I'm trying to think whether or not I agree with you or not. That the difference between being attached to the person versus being attached to the home. I mean, even in the Fourth Amendment and First Amendment context, they talk about it being an individualized, personalized, fundamental right. I mean, I have a First Amendment right. I have a Fourth Amendment right. It's not some sort of collective right. So I'm not sure the nature of that collective right, the nature of the individual right is going to be up to the text. So the nature of the Fourth Amendment right is, home and other things that are enumerated. First Amendment right is for the speech that's enumerated. But I'm not sure that I agree with you that's attached to the property. I think it's still individualized, even if it's in some sort of time, place, manner analysis where rights are differently strong and differently. I mean, you could just say it's a time, place, manner restriction. Yeah. Right. So that the ultimate private place is your home, and so therefore your rights must necessarily be at their apex, not because it's your home per se, but because there's no other competing interest from anyone else, within the confines of your home. So I don't know that it's attached to the property rather than the person. So I don't know about that. But and also I'd like to say once again, because you might be right on the felon in possession issue. Like, I don't know if you're right or not. I think there's a good case to be made. The current felon in possession law may be unconstitutional, at least in part, if not in whole. But I'm simply saying, can we push that issue aside for the moment?
Yes.
And deal with a law-abiding citizen, because in the end there may be no difference. It may be non-differentiable, but let's just pretend there are, so we can make the case easier. So if we're dealing with a law-abiding citizen, like, what does the right to bear mean? And it seems to imply some ability on its own terms to have a firearm or any weapon, because it's not firearm exclusive, it's arms. So I make that mistake sometimes too. The Second Amendment doesn't talk about firearms, it talks about arms. So it would be the ability to have arms at some version of the ready for their immediate use. I mean, that must be what to bear would be. And it seems logical that it would apply in some context outside the home. And again, this isn't to say, just like the First Amendment analysis, just like the Fourth Amendment analysis, that means it applies everywhere outside the home. We could make potential distinctions based on particular places and particular times and particular manners. So I think, and the nature of that would, of course, in the end, deviate from the First Amendment analysis. But then, of course, the First Amendment analysis isn't exactly the Fourth Amendment analysis, even though they have some parallels in their structure, right? Where the nature of where those lines break is a little bit different because the Fourth Amendment is a little different than the first. So I think for me, like, I would adopt the overall structure of the First Amendment, Fourth Amendment analysis. But of course, there's going to be some modifications therein because the nature of the right is a little bit different.
Yeah.
But I think the right to, so where I'm getting it from, going back to our original question, is it's the right to bear. I think the right to bear must mean, in some sense, the right to have a firearm on, if not necessarily on one's person, at least sufficiently close to one person to have it at the ready for an immediate use. And I think that must extend to some degree outside the home. So that's my logic.
I don't know. I still think, right now, if you're talking about just the core individual right, usually when you do have this, you're talking about, the expansion of it from where we're going to go. I do understand. I think the right to bear arms, it's an interesting question, because I think the court can do one of two ways. They can say the interpretation of the way they interpret it now is it, and not extend it to outside the home. But I think reasonably, if the Ninth Circuit's rulings are what you say they are, I'm assuming they're using a strict scrutiny test with the Heller, with the actually McDonald case.
Well, neither Heller nor McDonald set a level of scrutiny. They just simply said that no standard was inappropriate.
No, what I'm saying is
rational basis is inappropriate.
What I'm saying is that well, level of scrutiny that would be applied in the Second Amendment analysis under Heller is that if the state restricts someone's from having guns in the home, that you're looking at a strict scrutiny analysis.
I think that's probably right.
So that's what I'm saying. If the state says you cannot have a gun in your home, you're looking at a strict scrutiny analysis unless you're a felon. Which
may or may not be the analysis,
but
right?
Yeah. And then you're talking about if you have a gun outside the home on a city bus, then what type of analysis? And most courts will either use like a rational basis or even an intermediate scrutiny, like here that's what's happening in New York, where the gun advocates really are upset that they don't use the strict scrutiny analysis.
I think intermediate scrutiny might very well be right, because again, we can think about time, place, manner restrictions in the First Amendment, and even really in the Fourth Amendment, although we don't normally use that language, because we do treat different places differently. We even treat different times differently for when the police can conduct searches and how they conduct searches. So there is something there. So I think there is a valid time, place, manner restriction to be had. I just don't think it can go so far as to exclude all places. It would be the equivalent of, or even the vast majority of places. So it'd be the equivalent of a public university having, 10 by 10 square grid somewhere on this campus. Like, that's the free speech zone. So you can go there to have free speech when it's not near anyone, but nowhere else. That's like, I don't think that really flies. The university can prevent people from using amplified equipment, for example, when classes are ongoing. That makes sense. It doesn't make sense. So there's some restrictions that are valid. It doesn't imply all the restrictions are valid. And I think we're closer to all the restrictions are valid end of the equation right now in the Ninth Circuit.
But I think that's where you get into the lingo of, now, are you, is that more of a question for the legislature? Because now you're talking about how far do we go, right? The legislature is saying you got to get a permit. These are the permits. So you're saying that that's too restrictive. So you're asking for a heightened level of scrutiny because the legislature and the executive have said, this is the law. Get these permits. And you're saying it's an infringement upon a right. We're not talking strict scrutiny because we're not talking about in the home. We're talking about outside the home. So are you advocating for more of a rational, and you can't be advocating for a rational basis review because you lose a rational basis. So you're advocating for a heightened level of scrutiny based on an individual right, and your reasoning is for bearing arms, right? Because you have the right to bear arms. I think, I'm just going to call it what it is, Kurt. I think you're becoming an activist judge here. I think you're reading. You want to extend this right outside the home. I just don't think you have the precedent for that. I think the best you can get to be within your judicial philosophy is to analyze this in some way, analyze this under an intermediate scrutiny, like some intermediate scrutiny to this.
I mean, the only problem there is I feel like the alternative is making bear completely disappear from the text, because then, like, what's left for the right to bear? Is it in some sense not? I mean, the right to keep suggests the right to have it in one's ownership. The right to bear suggests one's immediate possession, doesn't it? I mean, so I don't think I'm being activist. It's just like I'm trying to give the word bear some meaning here.
Yes, but again, it's like the comma, right? You're a Second Amendment guy. What's the big issue with the comma, right? Some people read the comma as exclusion, so the comma.
Well, the comma isn't relevant to this because the comma didn't splice these phrases.
But what I'm meaning is that for all of you who don't know,
also I think the comma's oversold.
For anybody who knows anything about Second Amendment, academic law, legal, whatever. The comma within has been a huge discussion and huge debate, right? That comma means something. We're talking about a goddamn comma. So I'm saying,
as a matter of fact,
So I'm saying you're talking about how the interpretation of the words. We got 200 years of jurisprudence and them arguing over what the goddamn commas.
Sure if the commas exist or not, Nate. That's the whole problem with the commas. Yeah, this is a little fun factoid.
Like I say, it's so clear to me.
This is a fun little factoid. No one is quite sure exactly what the text of the Second Amendment is, because there might be one comma or there might be three commas. And the problem is the original versions of the Constitution don't agree with each other. Some of them have the three commas, some of them have one commas, so no one's quite sure what the text is, and the comma might make a difference. So that's all super fun. But we never had to get into the issue that far. So anyways, let's ignore the comma issue because I don't think it matters to this issue, because the comma isn't splicing keep and bear. So I don't think I'm being activist just so much as I'm trying to give the words bear some meaning so it doesn't completely disappear on the page. If the right to keep means the right to have it in one's ownership, and presumably if it's an individual right, then when one's home makes sense. If not there, then where, right? Because that's the core of the person's right. And again, I don't even necessarily think that doesn't mean that the state could at least put in some safety storage measures, just although DC went too far. That was Heller. But I think the right to bear must mean the right to have it in one's ready use. And again, under a time, place, manner analysis. So if we want to go to intermediate scrutiny there, then we could analyze what places and where. And to your question of is that a legislative question or a judicial question, I mean, the answer is both, but so is it in the First Amendment. So is it in the Fourth Amendment. There are some limits to which the state can't go, and then everything else is up for policy. So if the question is there any limit? And if there's no limit, then what's left of the right to bear? So I don't think I'm being activist as much as I'm trying to give bear some actual meaning here.
Well, but two things. Number one, I just don't think I think the support for the bear argument is just not rooted within Second Amendment jurisprudence, right? It just is not there. But I do agree that the word should have some meaning. But who has interpreted it, right? Because you're going to have to go and look. This is the way it's been interpreted. Here's some other stuff from back in the day. You're making an argument from when the Constitution was first. You're getting dictionaries from 1776 to see what the word bear meant from that point in time. So I definitely understand you're making the argument for Texas, and you're saying this is the end there, this and this. But I think now the Supreme Court, whoever is going to be on there when this does come up, is going to have to determine not only what it says, what it means, but then how it actually is going to fit into the overall scheme of what they've already got out there. And right now, the benchmark is this whole individual right that you have the right to bear arms here in this particular place. But what gives you the right to bear them outside on a public street? What gets you the right to bear them in a church? What gets you the right to bear them in a public building? You can keep them at home.
I think
what gives you that right? And that's
I think the public square and the street would be the next logical thing in this chain, because those are places that are held to the public in common. Mm-hmm. Is the public square in the street. So that would presumably be the next most after the home. Like what after the home, where are rights paramount? And the most logical answer to that question is probably the street and the public square, not necessarily the church.
All
Although
right,
that might
but
be
again,
for First Amendment reasons, but they have a private entity, so maybe
but
they can exclude you. So whatever.
but we would then have to admit that that's an expansion of right now. With what the court has said, as far as we go is here, and you can regulate here. You're saying that there's now these regulations that. Are you saying
I don't think
can't regulate?
No, I'm
outside
not
the
saying
home?
that. No, I'm not saying that either. And I don't think that's true in the First Amendment either. Of course, they can regulate in the First Amendment domain, but they can't infinitely regulate in the First Amendment domain.
Yes. Well, there's certain things they can't. There's certain things they can. They make no law.
Yeah.
Certain things you can't regulate. But what I'm saying is that in the First Amendment jurisprudence right now, we both agree the home is the king of the castle. But I'm trying to understand it. If you're trying to say, well, now we want to go to the street, to the public square, to this place, to that place, you can, but that is regulated, right? That's the issue with the Ninth Circuit. They're saying you have to get these permits. You're saying it's too hard to get the permits. So so my argument or my understanding is you're saying the regulations are too tough. What's your alternative? How do you, because you can't, it's not, you can't be a judge and say, well, I don't like these regulations, they're too tough. Here's regulations I would like. What's your alternative to this? People can just bear arms, do they have to get, permits?
Well,
you understand, what are you looking for in response?
If I'm trying to write this as a judge, right, I'm trying to write probably a narrow decision and deal with the rest later, right? So there's a question as to whether permits should be required, but that's a problem for another day. So what I would say is, for my immediate purposes, I would say a state gets to choose between concealed carry and open carry. They have to have at least one. They can't forbid both. And they have to issue, because we're talking about an individualized, personalized right, they have to issue it to anyone who qualifies with, background checks or whatever. So, and then we can analyze the question another time, because one step at a time on this analysis, we can at another time answer the question of, okay, what kind of checks, what kind of it do they have to do that? But for our immediate purposes, I would be satisfied if they said either concealed or open carry. Every state is shall issue, right? Every state is shall issue, and you can look at a person's criminal history and mental fitness to exclude, but and also that you would have the right to regulate to some, and I'd leave it kind of open for another day. You'd have the ability to regulate as to time, place, manner, and leave it at that. And then like what places, what times, what manners. Well, that's a different decision for a different day.
Yeah, because in other words,
that's kind of where I'd leave it right now. And I think
you would let it kind of go through the trial courts where, let's say, for instance, we're talking about, if you're talking about time, place, manner, we're talking about like at a concert, right? You can't have a weapon. At a school, you can't have a weapon because those are the wrong time, places, and manners. These
might be valid examples, yes. And then we can get into other questions another day. So I think the way to do this is one step at a time, not for least of reasons that you can't see the future. And also, the First Amendment jurisprudence that we know and love was not written over in a day. The First Amendment jurisprudence
years, right?
we know and love was written over what, 80 years?
Yeah, it's been
90 years. Yeah. So the First Amendment jurisprudence we know is loving today is been written over 70 to 90 years, depending on how you want to count this thing. Now, I think in the Second Amendment domain, we do have the benefit of being able to cheat a little bit because we have all that structure already in place in the First Amendment domain. And so we can borrow the structure at large to apply the second domain to save ourselves a little bit of time. But nevertheless, I think that you still have to do this in pieces. So I was like, okay, well, the core, right? The core of the right to keep and bear arms, from which the state cannot restrict, is the right to be able for a law-abiding person who is, doesn't have mental history and is 21 years of age or older, because that's classic. That was the age of adulthood in common law.
Defend your castle. Yep.
Yeah, right. Has the right to must be issued a concealed carry permit if they, pass a background check and maybe some basic competency, blah, blah, blah. And the state can regulate time, place, manner to at least some degree.
See, I think that sounds very legislative. I think that sounds very legislative, though.
Well, I don't
think you can throw the background check piece in there, right? You can't do that because if you throw the background check piece,
I probably wouldn't say that explicitly. Yeah. That's more in my own head.
Oh, right, all right.
So the way I'd probably write it is a little bit more alluding to it without actually saying it. But it's like, yeah, you have to issue a permit to every law-abiding citizen or every law-abiding adult, which implies the background check or something. How you actually execute that.
Do you ever find it fascinating? One of the things I always find fascinating about our government is that as citizens, we have the right to bear arms, but we don't have the right to vote. And
yes, because the right to vote is a collective right.
Yes, and it's based on state. And I'm shocked that most people don't realize that your right to vote isn't actually tied to the citizenship of the country. It's tied to the citizenship of your state, your residency of the state, mind you, not even your citizenship of the state.
No citizenship, because if you're residing in a different state but you're a citizen, you still would vote there.
No, if you reside, let's say you reside in Puerto Rico.
Yeah.
And you live in Puerto Rico, and you have also you won't be able to vote, because if you're a U.S. citizen residing in Puerto Rico.
In Puerto Rico the whole time, that's correct.
Yeah. But if you, like, say, for instance, if somebody moved from New York to Puerto Rico, they can't send their votes back to New York and vote. But if you move from New York to Paris, you can send your votes back to the last home state.
Are you sure?
And you can vote. Yeah. Unless your permanent residence is in New York. But let's say if you're a citizen and you move to Puerto Rico.
Uh-huh.
If I move to Puerto Rico, I lose my right to vote in federal elections. If I move to Paris, I can vote in federal elections by sending the absentee ballot back to New York. That's the way it works.
I don't know. You might be right. I was under the impression you could, and I might be wrong. So I'm not going to speak so I'm not going to make a positive claim, because I'm not sure enough to make a positive claim. But okay, I'll take your word for it.
All right, just I'll break it down. There are 3 million. There are 3 million citizens on the island of Puerto Rico, right?
Yeah, somewhere.
And they are American citizens, but they can't vote in federal They cannot vote in federal elections, right?
Correct.
The reason why is because Puerto Rico is not a state, and senators and all that stuff. Those are for states. Puerto Rico is not a state. Same thing with Washington D.C., which they're trying to fix. But anyway, so the way it works is that if you move from anywhere in the United States, from a state like, let's say, New York, to Puerto Rico and become a resident of Puerto Rico, you lose your right to vote in federal elections, because you're just a citizen, just like all those other citizens on Puerto Rico.
Okay, I'll take your word for it. Fair
enough. Then there's an absentee ballot piece where if you move from New York to Paris, you can send in the absentee ballot.
From a foreign country, I'm aware of that for sure. Yeah.
Okay. So it's weird. It's a weird thing, but it's funny because when I mention that to people, a lot of people don't realize how ingrained the right to bear arms is in American society, is in the fabric. And when we talk about this right, we're actually not talking about some like silly willy right. We're talking about like one of the fundamental rights. If usually when you tell people you actually have the right to vote as a citizen, but not the right, you have the right to bear arms, but not the right to vote, people are kind of shocked. They would think it's the opposite way, but it's actually not. It's the founders were more afraid of what's it called? The tyranny of the majority, and the tyranny of government. That's why the right to bear arms is there. But even now, I think it's that reasoning is done, right? The government can come kick our ass whenever it wants. They got all the bombs, they got all the power, they got all the money. So, ain't nobody. We're not rising up against the government anytime soon.
I'll respond to this comment from Shaz Z. The second wasn't written for rapid fire weapons; it was written for black powder weapons. My problem with that, Shaz Z, is if you extend that logic, then the equivalent in the First Amendment domain would be to say this First Amendment was not written for Facebook. It was written for handbills and magazines. It wasn't written for TV. It wasn't written for radio. So if you say the second isn't written for rapid fire weapons, the logical extension of that theory would be the First Amendment wasn't written for TV and movies and film and Facebook and social media. So I don't think that argument works. So I wouldn't go down that road, with all possible respect.
Yeah, and it doesn't extend to because I know it goes to the argument of nuclear weapons and this, but I think everything is within reason. No right is absolute.
Oh sure, yeah, absolutely. I don't think the right is absolute, and trying to understand it depends on how you phrase the question, but the right is nuanced, I think, is a better way to put it.
I think we've killed the Ninth Circuit issue, but I think it sounds fun though.
No, we got to debate firearms law.
That's true. Matter of fact, have you seen this whole, what was this thing? We talked about the death threats with salts.
Yeah, I don't fully understand why. Maybe next time you're talking to your BFF Katie,
Yeah.
You can ask her why her why her fans apparently. I know she makes a point of saying don't contact people, but why she thinks her fans are so like willing to make death threats and stuff. Because this is why are we making death threats against the attorneys?
I don't know. It's almost comical because I'm of two minds. Either this is somebody trying to, well, obviously we all know this is somebody trying to help her in some way, right? By scaring souls.
I guess. Although I kind of think it makes it look bad by proxy.
So it's when somebody could be doing this to make her look bad, or somebody could be doing this to help her. We just don't know. So I'm just saying, do I think they're going to refile? It's a strong possibility. It's a strong possibility.
Yeah. I think the probability is yes. I can't see any obvious reason now that they wouldn't, but we'll look to see what's happening within 30 days and go from there. I loved your video on Sidney Powell and her Tucker Carlson defense. I'm like, this is not going to fly at all.
You don't like the Tucker Carlson defense?
No, not for Sidney Powell. No.
Well, she's trying to argue litigation privilege without arguing litigation privilege. You know what I mean?
Yeah, well, litigation privilege applies to things that happen in court.
Yes. And I was telling Viva about that too. I was like, like he was saying, oh, and this falls with the litigation privilege. I was like, that's not when you're outside speaking to the press. That's not litigation privilege. Yeah.
Right. So it doesn't really work at all.
Yeah, I think that's Canada. I think in Canada they do that. But litigation privilege, for those of you who don't know, when you're in court and just say somebody's on the stand, you're trying to tear them up, you can defame them, right? Mm-hmm. And as long as it's happening in court and you heat a battle, that type of thing, and you have some good faith basis and all that stuff, you have this litigation privilege, and even your documents that you submit to the court, right, as an advocate for your client. But that privilege doesn't extend to when you're out there talking to the press. That's why you'll hear lawyers even, allegations, this is that, say things that they can only prove. And the reason is because they can be held liable for defamatory statements they said outside the courtroom, not inside the courtroom. So Sidney Powell's trying to have it both ways. She's trying to say that she doesn't want to be held liable for the statement she made outside of court under this kind of litigation theory. In other words, she's saying that by holding her accountable for those statements she made in furtherance of her litigation.
And it also doesn't help her on the other end, because her statements in the general sense and statements in general that she made in the press were consistent with her filings, right? They tracked. So if her argument is no one should have taken the things I said seriously, the next logical question is, why did you file them in court, Sidney? You can't file frivolous things. You have a duty of candor to the court. So if the things you said were merely opinions and you didn't anyone to take them seriously, why did you say them in court? How's that law license looking? Pretty shaky.
But how can you? I don't know. It's weird because at the end of the day, we all knew that it was all bunk. That all that election stuff, the Venezuelan Chinese connection. It's like the people, but on the end, I think I understand her. She was saying, well, the stuff I was saying was so crazy, no reasonable person would have believed it. And it's funny because I was saying all the time, I was saying what she said is crazy. Barnes was saying it. So on one end, she's right. She was saying crazy stuff.
Puffs, it was absolutely insane. But that goes to the strength of defamation. I mean, she was absolutely making statements of fact. And apparently a lot of reasonable people believed her, depending on what you view as reasonable. This is always a check on what the reasonable person is, right? It's like maybe we need to readjust our perception of what the reasonable person is. Like at law, the reasonable person was the man on the bus. And how many men on the proverbial bus were buying what Sidney Powell was selling? I think some of them were.
Yeah.
So I think we might have to lower our expectations for the reasonable person in our collective minds here, Nate. If we're going to be like the reasonable person wouldn't believe Sidney Powell, it's like, well, we have demonstrable evidence to the contrary, Nate. So,
Oh yeah. We got a lot of people who believe in Sidney Powell. Oh my God. Let's look at my chat, my comment section. You see a lot of people who believe that stuff.
Oh yeah,
but
they still do.
What it is.
They're hardcore. Yeah, they're hardcore. I liked the QAnon people when the White House was bathed in a green light for St. Patrick's Day. Did you see this? Where the QAnon people were like, green means go. And so we're expecting something to happen right now. The White House is bathed in green. Green means go. So now is when the revolution's going to come. It didn't.
These days always come, like March 5th. This.
Yeah,
I feel so sorry for the few people.
I do feel pretty sorry for them. And QAnon shaman is. Did you hear about this with QAnon shaman? This is pretty interesting. His lawyer got in a little bit of trouble. At least he got verbally slapped around by the court because So his client, QAnon shaman, the guy with the headdress and the war paint, is, as you might expect, currently in jail. And the Bureau of Prisons has rules for if a prisoner is going to talk to the media, right? So there's some sort of procedure for this. It has to be cleared by blah, 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 whatever. So his attorney, apparently not knowing these rules existed, created an interview between his client and 60 Minutes. You know, he scheduled it for lawyer-client time, right? He scheduled it for lawyer-client time, so it was unmonitored. And then he just shared the link with 60 Minutes. So QAnon shaman's lawyer got a little talking to by the judge on that one.
That's funny.
For defying the Bureau of Prisons. The Bureau of Prisons was not happy.
No.
Yeah, so I'm not sure about all that one. Also in legal news, Virginia just got rid of the death penalty. So that's notable.
Yeah.
First southern state, depending on your view, that got rid of the death penalty. So, and of course, Colorado recently got rid of it. Very recently. So it's interesting that the person who just committed 10 murders now can't be charged with the death penalty. So how's Colorado feel about that now?
Well, shit, I kind of think, living 50 years in a cell is even worse,
I think you might be right. We've had this discussion before. I've come to I don't know necessarily oppose the death penalty is the right word, but I've come to be what's more mild than opposed? Adverse to. So I've come to be something more mild than opposed. I'm lean against the death penalty. My reasons are less moral than practical. I don't think for me the moral arguments don't really work, but the practical arguments do. It's just a complete waste of everyone's collective time, and also it just keeps the bad guy in the cycle all the time, and the families are in some sense never have any certainty until the whole thing is done with appeals after appeals after appeals. And some of these things go on for 20 years or longer. It's like, how healthy can that be when you're continuing to wait for the date and it's another court hearing.
But hold on, are you? It sounds like you're advocating for a more streamlined process instead of, if the process was more streamlined, you'd be for it.
Well, let's look past that and deal with the immediate pragmatic realities. But I think sometimes about the Aurora shooter, because he got life imprisonment and now no one ever has to think about him again. Or I sometimes think about the 20th hijacker.
Oh yeah.
Who's in prison, like no one ever has to think about him again. So I don't know. I think the certainty, the cost, the stress on the system, and add in some moral bonus for whatever it does. And I'm like, I'm not sure it's really doing that much for us.
Look at the Boston bomber. He's at the Supreme Court now.
Yeah, the Boston bomber wants to rehear his death penalty case. That's pretty interesting. Do you know a lot about that? I'm not super familiar.
I haven't even looked it up. But I was going to check it out probably tomorrow. But I will say this with the I don't know, with this whole death penalty thing. It just seems, I don't know. I'm not. Part of me understands like the history of the death penalty and why it has, because let's say you're back in biblical times. People don't understand, if you arrest somebody, if somebody commits some crime, rape, murder, whatever, or even theft. Back then in biblical times, when you're a nomadic tribes, there's no jail. You know what I'm saying? There's you got to take care of that person. If you lock them up, they got to use the bathroom, they got to be fed, they got to be clothed. You know what I'm saying? That person becomes a ward of the state almost. And who's going to do that for years? You can barely eat yourself. So the death penalty was, this guy did something messed up, kill him. You know what I'm saying?
Or I guess another way of putting it is like all punishment would be corporal, I guess is the right word.
Yeah.
It's against the person. So, we're going to cut off their hand or cut off their finger, cut off their tongue or
send them out,
in some way or
get them out the community.
Excise them, which is just as good as the death penalty, incidentally. Exercising someone in the wilderness. But yeah, the concept of prisons is relatively recent, and as has been noted by many, all felonies were death penalties in common law.
Yeah, exactly. Not
felonies were a shorter list, but they still were all death penalties. So yeah, our modern sensibilities has modified.
So I think, but that and that's my point. I think with that ability to now be able to take care of people, to do this, and then not be such an overwhelming strain on the system. And like you're saying, you put them in and you forget about them. I think the death penalty now is I think the conversation is different than what it was before, or how it's developed from now. I think for some of the more horrendous things, obviously I understand why people want the death penalty, but I would just need, I don't know. It would be hard for me to give the death penalty to somebody unless I absolutely knew that they were guilty, because I remember reading this case in law school, the Texas fire case. I don't know if you're familiar with it, where there was a guy who they believed there was a fire at his house. One of the fire investigator went to the property and looked, and they did an investigation, and they believed that he had, there was an accelerant on the floor and he killed his kids. Come to find out a couple of years later, so he's on the death penalty, right? They kill him on the death penalty, and come to find out, the person, the techniques the person was using was all wrong. Like the whole report was like all messed up. So, from it went from him likely killing the kids to it just being a horrible accident. And the person, put together a whole bunch of dots that was unjustified in being put together. So this guy was killed, was murdered by the state, but it was a mistake. So I'm saying I would rather no one die and that not happen to that one guy than have a death penalty, And I don't know how you can do that, because you can't take back that mistake. You can't say, "Oh, my bad." We took this guy's life. There's no way we can take that back.
Well, as you pointed out, in antiquity, you really couldn't take any of them back, because you're maiming the person, or So I never, that argument doesn't do as much for me as it does for some people. So that prospect. So I'm not sure what that says about my morality, but it doesn't do as much for me as it does for some people. But the pragmatic arguments are a little bit more appealing at this point. So take what you can get, I guess.
Hey, what do you so now with these mass shootings going on too? We got all these mass shootings now. Obviously, the two things that have been coming up is gun control, and the Colorado one is gun control. Right? They got the bills, and the executive order is already ready to go.
Of course, they do.
Gun control is coming up, and
they already had two bills passed the House, so it's
but it's not even going to this. The filibusters got them nailed out. But then, so I just think that's just posturing. But then you have the hate crimes issue in Georgia. So I don't know if you want to tackle each one of them, but in Georgia it was hate crime. It's the hate crimes. Why weren't they labeled hate crimes and gun control? And then obviously in Colorado it's gun control. So I don't know. What do you think about the whole gun control issues now?
Well, I'm pretty strong Second Amendment, as you might infer from our earlier discussion. So I don't think a lot of these bills are going to do what they want to do, and they'll have adverse consequences. I did note that the Republicans, in part, are arguing how gun control is racist. And as I'm sure you well know, gun control has some very negative roots in racism. The South imposed gun control basically to disarm Black people and take their guns away. And as the left keeps reminding us, the police in general have, at least according to the left, and you can debate whether or not this is true, but at least according to the left, that the police more often go after minorities. So if you pass a law against guns, aren't we just back to stop and frisk and making other things against minorities? Won't this hurt more minority communities? I thought we wanted to defund the police, but we also want to make certain gun possession illegal. So I'm not sure how those two things square in the same circle, but okay.
No, I hear you. It's I whenever I talk to my anti-gun people, they bring up the European example, the European stuff. But it's interesting because I don't think the European model would ever work in America because there's we're too big. And I also think, it's just that there are more guns than people here in the United States, right? There's like 3 guns for every person or something like that. So I just don't think it's but I just don't think it's practical. No, it's just like a lot of guns. But I don't think it's like practical for us to ever go to a banned gun society.
Well, Kamala Harris keeps telling me that she doesn't want to ban my guns, and then goes on to say how she wants to ban my guns. We don't want to ban your guns, and here's a list of guns we want to ban.
Well, I think we're talking about how much regulation should the government I think an assault weapons ban makes sense. I think sensible background checks. I think psycho people shouldn't have guns, and I think felons shouldn't have guns. Those are things I think are reasonable. Now, if me and you can agree with those couple of things, then I think we're all good. But I think right now some of the positions are just too.
You do know the total number of people killed annually by all rifles, let alone assault rifles, but all rifles is less than the number of people killed with knives and hammers.
I would agree with you. I would say okay, yeah.
So how big a problem is it that we're talking about here?
It's just like I'm saying, the amount of people killed with nuclear weapons is 0, right? But I still don't want people having them. So it's not about the fact that if they do kill people, it's the fact that the ability to kill mass people, for one particular weapon. That's all I'm saying.
Well,
I don't want you having a nuclear weapon.
I mean, the biggest problem also with assault weapons is because unlike the term assault rifle, which does have a definition, assault weapon doesn't have a definition. Now in the was it 1996 Gun Control Act, if memory serves correctly, they did give it a definition. If memory serves, and I'm going back to 1996 here, the definition
was assault weapons ban. The assault weapons ban you're talking about, right?
Yes, the assault weapons ban. Yeah. Was it 96 or 98?
I'm not sure. I think it's 96.
Yeah. Anyways, so I believe the definition at the time, if memory serves correctly, was it was a rifle of certain length. It had a detachable magazine, and then it had to have, I think, any 2 of various cosmetic features. Like it couldn't have like a bayonet lug or a grenade launcher lug or a barrel shroud, which is the part that goes up. Part the barrel shroud, and a pistol grip and things like that. So the question is, what separates a rifle from an assault weapon? And particularly because if you look at some weapons, like the Ruger 14, you can get it customized so many different ways. On one, it looks like one configuration, it looks like your son's first gun. Another configuration, it looks like lethal weapon of war. So I'm not sure the cosmetics are really doing it for. And of course, under the assault weapons ban, they would make very trivial changes to get around the regulation. So what was the point?
Yeah. I don't know. I'm just saying, it just seems like we all agree with the same points. And I agree with background checks. I think it's unreasonable to say that there should be background checks. I believe people who are mentally unstable shouldn't have guns, and I do agree that assault weapons ban makes sense. I don't want people with military weapons. It's, if 2 people died last year, that's fine. I think somebody in the chat was saying Nagasaki and Hiroshima. Yeah, but that's 1945. We were talking about how many people died from last year, right? You said like 8 people died last year. Even how many people died from the atomic bomb from last year?
Like even the term military weapon, it's not 100% clear because what that exactly means. Because I mean, for example, the Beretta 92 FS is the standard sidearm for the military, which is a standard pistol. I think it's called the M9 in the military, but it's essentially the same gun. So, and of course they use shotguns and rifles, and so what exactly a military weapon is?
Well, just so what I'm talking about, because I can't talk about what they're talking about because I just don't know. What I'm talking about, regular handguns, things of that nature, things for personal use, things you keep in your house, that's fine. If you want to go deer hunting and stuff like that, those things would be fine. I'm thinking automatic machine guns, Gatling guns, things of that nature. I don't think people
machine guns are really, really hard to get.
I don't think. I'm not saying they are, but I'm saying they should be banned. You know what I'm saying? I'm saying things that can get a mass
banned now.
That can do
86 80 whatever gun, 86 Gun Control Act. They're pretty. Yeah, that
No,
was 86.
well, what I'm saying is things that cause mass, that can kill a lot of people in a short amount of time, that don't really have any real recreational use or any real use, or people, or you really don't need to protect your home.
Look,
That's what I'm talking about.
I've
There's a list.
I've actually had occasion to fire an automatic weapon before, and let me just say, it's a lot of fun.
Oh no, I wouldn't say it wouldn't be fun, but what I'm saying is that I think we could all come to an agreement on which weapons are just not appropriate for a civilian setting versus something that I would expect to see a tank or something like that on a battlefield. You know what I'm saying? And we can. Oh, you can buy a tank, but that's what I'm saying. I'm saying we can come to the details, or we can wrangle about the details, but we all know where we want to get to. And so I want to be clear. You do agree with the background. Like I don't. Every time I speak to you about this, we seem to agree on the fundamentals. Maybe just how we get there, or what's going to be on the legislation. That's what we just maybe disagree with.
Well, I mean, I don't know if I necessarily agree with any particular regulation. I wouldn't necessarily go that far, but I agree with the concept of regulations in general, you just the same way as I did in the First Amendment domain.
Yeah, but you remember you said
but we were talking about. I thought I was relatively clear that I was talking about like the most core aspect of it. Like it must be if it's anything, it must be this, right? So it doesn't necessarily imply it's not less than that. It's like if it means anything, it must mean this. So I wasn't necessarily saying you couldn't go further. I thought I was fairly clear about saying that those were arguments for a different day for exactly that reason. So.
Fair enough.
Yeah. So what else has happened? What else you want to talk about? I'm in a pretty good mood. We can talk about anything. What's on your mind, Nate?
Nothing. The only thing. What's the other thing that happened? We had the Sidney Powell thing that we talked about, and we had the hate crime thing in Georgia. It's now thinking about it. I can see an argument being made now. For those of you who don't know, when it comes to criminal law, hate crimes are extremely unique in criminal law because it is talking about motives. And proving motives is something that's extremely hard in criminal law. Usually, you're trying to prove intent. The person planned to do this, the person recklessly did this, so forth and so forth. But proving motive is really hard because you got to go into the person's background. You got to do it's a totally different ball game. And not only is it harder, it's a pain because when you really start getting into motive, you can really go into a well of, like, for instance, if you're black and 90% of black people kill other black people, or 90% of the people who are killed who happen to be black are killed by other black people. Same thing for white people, same thing for Hispanics.
Yeah, that's very true.
Right? The people generally kill people who they live with.
Are you talking about black on black crime?
Black on black crime, white on white crime, and everything on everything crime, right? The 90% of Asians kill other Asians, right? Who are killed. So, but I wouldn't say all those people are racist against Asians, right? Because now I gotta prove. So it's tough because you're gonna go back and say, well, this serial killer in the Asian community who only killed Asians, was he doing it because of hate, or was he doing it and he happened to be Asian? That type of thing. So that's what I'm talking about. It can get real iffy when you're trying to prove motives. And here, I think the motive for race isn't there. But I do think, because if their only argument is he killed 6 out of the 8 people who died happened to be Asian. That's one aspect. Look at the thing at Boulder, Colorado. 10 out of the 10 people who passed away happened to be white, right? I wouldn't say that guy was.
So that makes it a hate crime.
Right? So I wouldn't say that makes it a hate crime. But I would say if you look at everything in its totality, the fact that he frequented these places, the fact that he was making love to Asian women, I'm saying, all those factors. I think hate crime, but I think you could make an argument for gender, a hate crime for gender, and I think that argument's a little more tenable, I should say. And that's because of 2 reasons. Number one, he went there to kill women, right? He went there to kill women who were tempting him to have sex with them, and he would pay. So that was his goal. His goal was to close those places down, and that he was tempted by these women to want to have sex with them. So is that a crime based on their gender? He did kill mostly women. He was there, you could, I'm reaching here. You could make an argument, but I think at the end of the day, when you kill 8 people, doesn't matter if it's a hate crime or not. This guy's getting a chair. Georgia's the death penalty state. This guy's not coming out, so it's over. Yeah,
absolutely. So, I don't just because okay, I had so many different thoughts at once I couldn't come up with which one I wanted. So let's try that again. First of all, dealing with a hate crime. Nate makes a very important point, and I want to make sure it's not missed. That hate crimes, I think, are the only example where motive is an element of the crime.
Yeah.
There's no other example where motive is an element. Intent is different than motive, which lots of lawyers screw up, and it's hard to keep straight in your head sometimes. But yeah, normally you don't have to prove motive. And sometimes motive can even be excluded from trial if it's going to not be helpful at all. So it's not. So this is one of the reasons that some of the conservatives, when hate crime legislation were first being proposed, had problems with it because it was fundamentally changing the nature of crimes were. And of course, everyone says it's because, well, you hate races. It's like, no, there's a philosophical rationale that makes it a little bit more problematic.
Yeah.
So that was thought number one. And then thought number two is motive is hard to prove. And because how do you know unless he tells you what his motive is in this particular crime? It's a little bit hard to say. Like, even in general, if he hates Asians, or even in general if he doesn't, what does that speak to this crime? Isn't that just propensity evidence? Like, in general, he doesn't hate Asians, so this must not be a hate crime. In general, he hates Asians, so this must be a hate crime, right? Isn't it just propensity evidence? So it doesn't really work for me.
Yeah. I don't know. It's interesting because I think I do understand why people in the Asian community want it to be labeled a hate crime.
Mm-hmm.
And but it's just like, what's the criteria that you want to use for it to be a hate crime? And I do understand Asian American, issues that are happening in the Asian American community with them being attacked because of the anti-Asian sentiments out there. But I just don't know. Law enforcement's job is to look at the facts and try to make the best possible determination of those facts based on what we have in front of them. And I think the facts that we have in front of us with this particular crime, I just don't think it's there. But one thing I did want to ask you before we get out of here is the U.S. women's soccer team. Soccer team.
What are they up to now?
Megan Rapinoe. So they testified in front of Congress today, and they did the whole thing about equal pay. And they're still pushing the lie that their lawsuit was because they're not getting paid equally as the men. How do you feel about that?
No, I mean, it's completely stupid because let's everyone remember what the judge found in that thing. Okay, the women sued because if they had been paid under the men's contract, they would have gotten paid more. Why didn't they have the men's contract? Because they themselves didn't want it. The women's team has a union and the men's team has a union. The judge says, who I'm inclined to believe, the judge says the women were offered the men's deal. They said, you can have this contract too if you want it. And the women said, nope, we don't want it. The men's contract, incidentally, basically is pay for performance. It's a commission, essentially. Yes. The more you sell, the more money you get. Or in this case, the more success you have, the more money you get. If you don't have any success, you don't get any money. If you have lots of success, you get a lot of money. The women's deal was salary plus some commission. We're going to give you a base rate, and we'll give you a lesser amount of commission for success.
Yes.
And the women who were incredibly successful obviously would have done better on the men's deal, but they are the ones who didn't want it. So it's like, how do you with a straight face is my question. So either you have to believe one of two things. It seems to me. You have to either believe, one, that the judge who wrote this opinion was just wrong in the recitation. The women weren't offered the men's deal. That was just somehow wrong. The judge somehow screwed up the fact. So you have to think either judge screwed up, or two, how can you with a straight face, if you're the women's team, go into like, we were discriminated against because we didn't get the men's deal. Why didn't you get the men's deal? Because we rejected it. So you had negotiating power. Yes. And you had the ability to choose what you wanted. Yes. And you selected against this collectively. Yes. What's the problem exactly? I don't understand how you can make this argument with a straight face.
Well, the Republicans, they brought it out. They said, well, Megan, 2017, you guys went to court talking about equal protection, right? You guys were represented by a union. You guys went and negotiated, right? And on top of that, after the deal was signed, you said this, greatest deal ever, transformative in women's sports. And then you went to court and said how much you hated the deal that you agreed to. And then on top of that, the thing that upsets me about this case so much is the crime in the media. It's the media that's pushing this, right? The media, no one has asked the simple question. If they offered you the men's deal, why didn't you take it? Right?
No, we can't ask that question because it would go against the narrative.
And the second question is, if it's about equal pay, should the men be suing? They made less money.
Right, because the men would have been better off if they had the women's deal.
Yeah.
They would have been better off under the women's deal because the men team didn't perform very well. So their commission wasn't very good because they were essentially on a pure commission scheme. So they also would have been better under the women's deal. So why aren't they suing for sex discrimination? If we had the women's deal, we would have been better off. As it turns out, both teams should have just handed the other team the deal and they would have both been better off. But that's where we are. It's like we collectively negotiated a contract and we got exactly what we demanded for in our contract. We got full performance. And now we're salty that we didn't have their contract, even though we could have had it. So, like, if one of these congressmen doesn't ask the question, like, why didn't you take the men's deal? I'm going to be deeply disappointed.
Oh, this guy says, he says, didn't the U.S. women's soccer team get hired? No. Let's just be clear. They got paid more per game, and they got paid more overall. So they got more money overall and more money per game. They did make more. They did make more money than the men. They just would have made even more money under the men's deal. So they did make more money. They just would have been. I think they would have. They were down about 2-1, something like that. If I'm even. Yeah, if they'd have been in the men's deal, they'd have made $66 million more.
How much did they make?
They made, I think, 44 million.
Okay, so a little bit more than
something like this. Yeah,
like so 1.5 times more.
But the thing is that they were salaried employees. They had they had pregnancy benefits. They had all those benefits.
The men did not negotiate for pregnancy benefits and maternity leave. They could have, presumably.
But I think the core thing that most people have to understand too here is that the women actually brought in more men. The women brought in more money than the men for U.S. soccer. But the problem is that when men go play soccer, they go to these, to the Premier League overseas and all that stuff and all that money. So they don't use U.S. soccer as their career driver, right? They go to those big European leagues and make millions and millions of dollars doing that. So this is kind of like their side job, where the women's U.S. national team, this is their real job, right? So the way they make money is going to be different here for U.S. soccer versus the men. So if that's the case, women said, well, hold on, this is our only game in town. This is, if we don't play for women's soccer, there's no Premier League for women. So what did they do? They started doing this, not at that level. So what did they start doing? $100,000. Just lock us in the salaries. Let's make us salaried employees. Let's mitigate this risk, right? Over time. We want to make $300,000 a year per player, no matter if we play in a game or not. The men don't have that luxury.
I mean, just for me, the women's deal looked pretty good. It's like you get a guaranteed $100,000 salary. You get all these guaranteed fringe benefits, like dental and healthcare and maternity leave and daycare, and like none of those things for the men because it was just a straight cash deal. It looked like a pretty good deal to me. So I don't think the women really made a mistake. It's just that they're salty that they would have made even more if they knew in advance how awesome they would be. So they didn't believe in themselves, I guess.
Well, I think the judge nailed it when the judge said they want all of the upside of the men's deal, but none of the downside of the women's deal. They want any of the risk. Yeah. Because the men play the risk. If we lose, we get nothing. But when we offered you that deal,
no guaranteed games under the men's soccer contract. There were no guaranteed games. Men's soccer didn't have to host a game ever. They didn't have to ever field a player ever. So even if you're on our team, we don't have to field you. If we don't field you, you don't get paid. Right? We don't have to have games. We don't have to field a player. If you don't show up, we don't pay you. I mean, the men were like, so USA Soccer could be like, well, we just decided we don't like soccer anymore. You get nothing. I mean, but they had all the risk. It was all based on whether men could perform or not. They could be cut at any time. I mean,
they can lose. They can lose. If they lose, they were out a whole bunch of money too.
Yeah, they lose. They get like nothing if they lose. And some of the women even got some money if they won. The women's deal looked pretty good.
But you know what?
Now they're testifying about how they are somehow bad contract negotiators.
But you know what they're trying to do now is that what the women are doing is that they're putting what they made, right, for winning the World Cup against what the men would have made if they would have won the World Cup. And like, look at all this money the men would have made if they would have won the World Cup, but we only made $200,000, not realizing that the reason why they made such a little, or they made only $300,000 was not because of any type of discrimination. It's because they rejected the men's deal and didn't want the risk, them not playing games, them not doing this. They didn't want to risk any of that. They said we rather have our money straight up, which I think anybody in any type of economics understanding economics, understanding the economics. Yes, for that. What I'm saying, understanding the economics of it all. You understand the less risk you take, the less money you're going to make, right? That's just the way it is. If I'm paying you $100,000, no matter if you're playing a game or not, that's less risk. So I'm not going to pay you the same as I'm going to pay the men, because I don't have to pay the men at all. As you were saying before, they lose, they don't get paid. You know what I mean? If you lose, you still get paid.
So yeah, the women's soccer complaining thing does drive me a little bit up the wall, perhaps more than it should. But when I read the judge's opinion, I'm like, you cannot be serious, and apparently, yes, you can be serious. So all right.
Well, they're essentially calling the judge a liar, saying the judge is lying. This is all, but. We'll see, but that's what regular appeal. So I just don't think it's a good example of equal pay. I think there are better examples. That's what, and I think those should be used. But I just don't think this is a good example of equal pay, because the women, essentially, you got to say this: the women negotiated a bad deal for themselves, and now want to say we want to be paid like the men.
See, I only really think it was a bad deal. It wasn't as advantageous, but the deal was pretty good. I mean, because the men didn't get paid if they didn't play, even if it was due to injury. The women got guaranteed pay, even if injured. They got guaranteed games, guaranteed field times. So the men, no guaranteed games, no guaranteed field times. The women, guaranteed games, guaranteed field times, guaranteed pay if you got injured. Men didn't. And
with all that, they still got paid more than the men.
Yeah.
And with all that, they still got paid more than the men.
I don't know what the women are complaining about. They want to go back in time, and they wish they made different choices.
They want both contracts. They want their contracts with the safety, and they want the men's contract with the high bonuses.
This could be depending on how deep you want to go into manosphere land, the manosphere. Mm-hmm. This is a critique of the manosphere against feminism in general, that women basically want to have all the upside of being a male with none of the downside. So that the manosphere says that in general, as I understand it, not to represent my views on this, but just to characterize what I understand their views to be, is that feminism wants all the upside being men and none of that downside risk. It's like it doesn't really work. Usually with the bitter comes the sweet, with the good comes the bad. Normally, when you have an advantage somewhere, you have a disadvantage somewhere. There's no free lunch, basically. Yeah. So it depends how deep you want to go into that land, but yeah.
But I think that's a dream for everybody. I don't think it's just women. Like, I would love all the upside and the downsides too, and I think that's what we all hope for. But I also think I don't know. It's when you're talking about equality and things of this nature, there's a lot more that goes into it. I know it's the easy thing is to say everybody should be paid the same, but not everybody's making the same amount of money. I like with Ronda Rousey, the first, the female competitor, and I'm thinking, what she said? She was on. They asked her. They said, "What do you think about this pay equality?" And she said, "Well, listen, I'm the richest woman athlete in MMA," and she was like, "You know why? Because I bring in the bucks. I make the money, so that gets me to make more money." And she said, "That's the way it should always be." So I understood.
Why she get paid? Because she's a huge draw. Yeah.
Yeah. So now for the women's soccer, I think they're making more money than the men. They made more money than the men. I think everything kind of equaled out there. But if we really think about it, men's soccer, if the men won the World Cup, men's soccer for the FIFA brings us something like what? $4 billion or something. It's like some astronomical number.
I have this sort of view that the world is relatively at peace and will be until the U.S. men's team wins the World Cup.
Oh,
if the U.S. men's team ever wins the World Cup, I think the world comes to an end.
it's even if they make it to the World Cup, it's going to be crazy.
We've done okay.
We've won it before though, like in the 60s or whatever. But
did we ever win the World Cup?
I think it's in the 60s or something. It's way back in the day. I believe so. Maybe I'm thinking about another country, Britain or something like that. I don't know.
I don't think the men's team has ever won the World Cup.
One thing, but my point is that those two, the women's team and the men's team don't bring in the same amount of money, right? They don't bring in the same amount of money. And FIFA and men's soccer brings in a hell of a lot of money to women's soccer. So maybe if that's a point of contention. I know that's the same argument for the NBA, right? The NBA women say, WNBA women say we want to be paid equal as the men, but that's just not unrealistic. The men's NBA brings in billions of dollars, TV deals, and all that. The women's they can barely put 10 people in the stadium. Not to say it's not a good product. It's just that people's got to want to spend money, and it's got to bring in those dollars for us to pay you. If we're just paying you because you're women, then that kind of defeats the purpose of us paying you for paying you what you're worth for the things that you produce. Not to say women are worth less, but it's just everything. It's like, what's it called? Like there are certain fields that unfortunately men get paid more than women. There's certain fields that women are going to be paid more than men, but I think the answer to both those questions is just more nuanced. It's just, I wish if we were a communist society, it would be so easy.
Nuance is great because, it's like, even though we tend to be different sides of political aisle, at least we can have an intelligent conversation. And like you and I could have an intelligent conversation about some of these issues. And that seems impossible for our political environment, which is really annoying.
Yeah, no, but I think as long as we're honest, like I don't think anybody's saying that women shouldn't get paid equally to men if you're doing the exact same job, for the exact same labor, making this. If everything is equal, then I think you're an idiot if you say women shouldn't get paid identical as men, right? But I also think it's not right to say, a woman can, if we're working sales, she could bring in $2 worth of sales and get paid the same as I am making $1 million worth of sales. I just don't think that's right either. I think there's a balance, but that balance has to also include, maybe training that person, getting that person up to the $1 million mark, or giving the secrets out. But I don't think I'm less likely to be in favor of a handout than a hand up. You know what I mean?
Mm-hmm. Yeah, absolutely. Well, I think I'm going to cut off the conversation there. I've really enjoyed our conversation today, as always. Don't forget to check out my friend Nate the Lawyer on his channel. He produces some really great content. I've really been enjoying the stuff he's been producing lately, with going over these the shootings and other things, where he kind of lays out all the facts and lays out the law and leaves it open. I really like that that format that you've developed. It's really working well for you. So I recommend checking that out, and it's really good content. So congratulations on that.
Thank you.
And as always, I want to thank everyone here for being a guest. Remember to subscribe if you haven't already. I'm going to peace out at this point. Love you guys.